we commonly, typically say out here in Kenya, when we think about dispute, let us meet in court. And that defines our approach to dispute resolution. When parties enter into contracts, they have the option of selecting the forum to which they can resolve their disputes. But often what we have found, even where that choice has been made, the forum may be, for instance, in arbitration, parties still go back to that typical way of approach to disputes, that is, let us meet in court. However, that is not to say that these other methods of dispute resolution, other than conventional litigation, are not in use. Many would be surprised to know that the disputes that eventually make their way into the doors of the court form a fraction of all the disputes in our community. So conservative figures place it at 5%, and 95% of other disputes are resolved elsewhere. It is this elsewhere that we refer to as, some will call alternative, I prefer to call them appropriate dispute resolution mechanisms. Having said so, you asked the question, where do we stand? Arbitration is largely used by the commercial sector. Almost every other contractual transaction has a dispute resolution clause. And whenever that clause is kicked in, an arbitrator will be appointed. They will listen to the dispute. Eventually an award is given, and those parties either by their own consent will enforce it, or in the case where there is no enforcement, the parties will draw to court to assist in the enforcement of those awards. And so we can safely say, at least in the commercial sector, the uptake of arbitration is already well on course.